The first question that I typically get from commission salespeople, and this is like number one with a bullet, is do I need a contract or not have a contract? Am I better off to have a contract or have none at all? And I'm going to give you the lawyer's answer, and I'm going to give you the controversial answer, okay? The lawyer's answer is, of course, well, it depends. And what it depends on is the law as it exists in your state. There are over 30 states in the United States that have sales rep protection laws. Some are very good. Some are very powerful, granting reps significant territorial rights. Others, not so much. If you live in one of those states where you have very strong rep protection statutes, I'm going to tell you that you shouldn't have a written contract. And that's the controversial part. For a lawyer to tell you that you're better off not having a contract than having one is born out of the reality that if you live in a state that has strong rep protection statutes and you sign a contract that contains different terms, you've probably just given up all those protections afforded to you by your own state's law. And so as a result, you're better off having no written contract, formal written contract at all. If you're in one of those states that doesn't have such great rep protection statutes, you're probably better off having at least some form of letter agreement. And by that I mean some sort of very brief communication at the outset of the relationship that says, this is my territory, this is the commission rate you're going to pay me unless I agree otherwise before business is booked. This is when you're going to pay me in this business 30 days after shipment. And you're going to send me commission statements. There are no reserved house accounts. I look forward to working with you. You don't need to have them sign it. A simple email will do. For example, in 2006, I represented somebody that some of you folks probably know by the name of Danny Welch, who was the independent sales representative for a lot of companies, including Ocean Pacific. I represented Danny in a case where a company out of Connecticut, who I won't name, owed him approximately $200,000 in unpaid commissions on sales to Target, Maurice's, and the Buckle. His position was, at the beginning of our relationship, I sent you an email that said my commission rate is 5% on all accounts except Target, which is 2% because of their margins, and we have to work through TSS, Target Sourcing, or AMC, all right? That's it. That was the email. That, we contended, was our contract because we sent that email and we started working. Their position was, no. We had an understanding that we would pay you a variable commission based on what our margin was, even though we didn't share that with you. And so we haven't underpaid you these commissions. The jury heard all the evidence and came back and said, no, the email that Danny sent at the beginning of the relationship, which was only 2 sentences long, was the contract. And based on that simple email, awarded him $200,000 in unpaid commissions. Okay? So the moral of the story is a short memo of some kind that at least outlines the basics of your relationship is always the way to go.